Hello, can you all hear me?
Yes.
Well, welcome to the annual ARIAS UK Half-Day Conference and AGM. I'm David Scorey, the current chair of ARIAS UK. I'm delighted to welcome you to what will be, I hope, an informative, enlightening, possibly entertaining morning, but also one of some importance, given that I think this is the largest attendance in living memory of an ARIAS UK half-day conference. So long may it continue. So thank you very much for coming. I also wish to extend, and people on screens, they are also, wherever they are, welcome. Hello. I want to thank Jonathan Sacker and BCLP for allowing us to be here in these marvelous surroundings. And the most important thing I want to tell you today is if there is a fire, don't panic, go out there or go out there. And I think that was what I had to say about housekeeping. Now, timings today, we're going to hear from Paul Jaffe in a minute on the new clauses and me briefly on the new questionnaire. We're going then to have Peter MacDonald-Eggers at 10, followed by coffee, and then Sir Bernard and Trevor are doing their double act at 11:15. So, without further ado, Paul Jaffe, stalwart of the ARIAS committee, is going to talk to you about our new clauses.
Thank you, David. The clause will be on the screen, but quite illegibly, so Jonathan's kindly produced a few copies. Yeah.
Only 10 copies.
Yeah, it's a lot of sharing. Ever in the enviro.
Just to remind you that they exist.
So, good morning, and thank you for letting me introduce our new combined arbitration clause. I think I'm only presenting on one clause today, but I just should say, I've been asked to say that I should, that any views that I might express are mine and not necessarily those of my employer Convex. So this is what I wanted to cover today. We're launching a new combined clause. So I'd explore what it is, why we thought it was necessary, and then a bit of compare and contrast with the standard clause and the fast track clause and rules. So this is the new clause. It's called the combined clause. It's got a subtitle, which is the snappily named ARIAS UK Fast Track Arbitration for Lower Value Disputes and ARIAS UK Arbitration Clause for Other Disputes. We probably don't deserve any awards for literary finesse, but it does what it says on the tin, or in this case, actually what it says in the clause. So the new combined clause is at its heart an incredibly simple concept. It combines the standalone existing fast track clause with the standard ARIAS well-known arbitration clause. And it provides fast track process and rules to smaller disputes. And there's a default threshold or limit in the clause of $500,000. The full arbitration process and rules apply to disputes that are with a value of 500,000 or more. So I think part of the billing for this was the effects of the clause. This is I think the only bit that relates to effects. So the $500,000 threshold or limit, as I see it, applies to the dispute in the arbitration. So if you have a claim under your reinsurance policy or insurance policy for $2 million, but 80% of the market has settled, the dispute in the arbitration is only worth 400,000. So under the clause, as I see it, fast track procedure applies. If only 70% of the market, on the other hand, had settled, dispute in the arbitration is worth 600,000. This is the full extent of my maths. So the standard arbitration process applies. When considering, of course, the limit or threshold is a default and can be changed by the parties, obviously. And when considering that, it's probably worth bearing in mind that the successful party will generally recover its costs. The only other thing that we thought was a little bit wizzy was the clause contains a choice of law provision for the arbitration agreement, as well as providing a default choice of law clause for the contract and providing for a seat of the arbitration. And that is a response to the Supreme Court ruling back in 2020 in Enka and Chubb, which emphasized that they are, in fact, different things, the arbitration choice of law and the contract choice of law. And that is, those are indeed separate from the seat. So I think that's being fixed by the 2025 Arbitration Act, but the Act, as I understand it, not yet in force. In any event, it was felt it was probably a good idea to clarify that for the future. So why did we think we needed a new clause? Bearing in mind that both the fast track and the standard clauses have been in existence for some time. So as I see it, until now, the contract would have had to contain one or other arbitration clause, unless the parties had negotiated a bespoke way to combine them. And our understanding, especially from the broking community, is that most parties wanted the standard arbitration process for higher value and complex claims, so they rarely put in the fast track clause. The problem with this is that for the smaller disputes, when the claimant would want to agree, which would be post-dispute, that the fast track rules should apply, the respondent would generally refuse, quite often, for tactical reasons. And then, of course, the claimants would find themselves without access to justice because of the small dispute relative to the high costs of the full-blown procedure. So even though the costs were awarded to the prevailing party, which would mitigate that financial block, most cases, as we all know, settle before an award. So users found the financial hindrance to arbitrating small disputes was still remained. So doing a little compare and contrast of standard arbitration and fast track rules and processes. So overall, the standard rules envisage a high level of party control, while the rules encourage a lack of delay or expense and encourage the arbitrators to adopt procedures suitable to the circumstances of the particular case. In practice, or at least in my experience, the process generally resembles that of a high court case. By contrast, fast track envisages a much higher level of arbitrator control. In fact, the first page of the fast track rule states that the sole arbitrator will take control of the procedure immediately upon appointment and provide the arbitrator as the widest discretion permitted under the law governing the arbitral procedure when making orders and directions. And the fast track rules then reinforce the emphasis throughout, really, on speedy and effective cost-effective resolution in various ways, which I tried to set out on this compare and contrast slide. So, for instance, a preliminary meeting must be held. There's a lot of, it's very prescriptive, right? It must be held within 7 days of appointment, at which directions and orders for the speedy, final, and proportionate determination will take place. The number of arbitrators is, of course, 1 under fast track versus the 3 under the standard rules. And the nature of the proceedings, unlike standard rules, fast track contains a presumption that the process will be on documents and written submissions alone. Of course, the presumption can be overridden if the case requires witness evidence. And I mean, again, to emphasize, both sets of rules provide for a wide level of arbitrator discretion. And then fast track introduces the concept of a closing date, which again, I think that's another must be held within 4 months of the commencement of the arbitration, and it envisages an award 14 days thereafter. Not sure how popular that's with arbitrators, but so again, costs, goes on and on the comparisons. Costs are generally awarded to the prevailing party, but again, fast track encourages a limit on the recoverable costs to encourage cost-effective resolution. And finally, I've just tried to tot up the estimated timings of the entire process from commencement to award. I put 12 months for standard arbitration. I have to say that's probably, in my experience, quite optimistic. You need to really go some to get an award within 12 months, whereas AFTAR envisages 5 months. So that's really all I wanted to say, other than we hope this is a useful addition to our suite of clauses and will be taken up by anyone concerned that smaller disputes may not be able to be arbitrated in a cost-effective manner. Do we want to do questions now, or yeah? If anyone has any questions, I will be around in the coffee room. Oh yes, sir.
Well, just briefly, when you mentioned 25 factors, anything that it's
That's a good question. No, my learned friends in the room. No, I don't know why. Yes, Mr. Robson.
just to make a point for people here, obviously the committee is looked at 500,000 from the broker perspective. So evidence personally, we were looking at a higher amount because obviously it's in our interest that we want any disputes to be settled reasonably and quickly, and you know, we don't can't even have reinsurers, which also clients most of the time in that space, in the reinsurance space. So I would expect to see the brokers push for a higher number. A number of 2 million was mentioned, but I think it'll probably just to mention.
And I guess, you know, there may be a whole pile of factors why one would want lower or higher, but one of the factors is, you know, if you want a market person on your panel and that market person is not comfortable being a sole arbitrator, you may be inclined to go for the 3. Yeah. So, sorry, Mr. Brent. So, no, I don't believe so. I believe you were a chair when the fast track was introduced, but I don't believe there is. But I could check. I'll check that, shall I? If I'm mistaken, I will come back. No.
So I think when we did have an initial discussion about that, we wanted to leave that flexibility open because that point wasn't in the original ARIAS. So there's never a bad thing to have a little bit of scrutiny.
Yeah. Yeah, great.
You may be right. But I don't know what people think. Every meeting I go to, everyone hates the prospect of appeal to them. Can we just take a straw poll here? Who thinks that there should be a prohibition on appeal to the court following an appeal? Anyone? Everyone who's in favour of appeal. Every other meeting I do.
I mean, it's quite interesting in that Unipol case where you had the 2 awards being appealed at the same time. One had to have been wrong, didn't it? Does seem to provide.
The ICC, the RCIA, all the major institutions effectively have an exclusion for right. And that's because of a lot of market research work that they do, and that is supported by the people.
Yeah, and I don't know if it's a difference in insurance, reinsurance, where we really do like to see some precedent.
I would say insurance and shipping are the big sectors that do not sort of take right.
For now. Yes.
So, Bernard, you may know, but we did some research a while back, but the number of successful appeals of reinsurance arbitration awards since the 1996 Act is less than 5, probably 3. So I think in a way, that's the control mechanism. The court tends to do what it should do and say, I'm not going to interfere. Very occasionally does it. And that's why I think it's useful to have the opportunity to go to court if there's a view on one side or the other that there's been serious inequality or iniquity or whatever. But I think the control mechanism is the court doesn't often, in fact, almost never intervenes. Not so in shipping and other cases, though. It does intervene.
Sorry to be a bit controversial. The thing is, certainly in reinsurance arbitrations. Sorry to be a bit controversial, but certainly in reinsurance arbitrations, which are obviously confidential, everybody knows what's happening, and they can form a precedential point of view, or whether it's worth pursuing further arbitrations. So sometimes the right of appeal in reinsurance is a good way if it's going to have that kind of effect.
I'm biased. I'm a mediator. I was surprised that you don't have the provision for mediation for the clause. I mean, these are not large sums. Do you need to go to arbitration and wait 5 months for an award?
No, well, of course, you can mediate.
I know you're probably a solicitor, so I understand why you say this, but I'm just raising the contrary argument.
So and some people do have a mediation precondition in their arbitration clauses, dispute resolution clauses. When I was buying, I was actually quite against that, because if I wanted to mediate, I could always mediate, but I didn't want to have an extra delay a mandatory delay put in place before I could take which is often regarded debt collection to get a resolution. But of course, mediation is a huge useful part of our community.
I think from my perspective, building on your mediation point, we took the view that most practitioners, particularly at the senior level in the insurance and reinsurance market, would be able to initiate mediation on the side. And what might help them was at least an articulation clearly in the opening proceedings of the fast track clause of what the parties' positions were. And then mediation is always something that you have that almost, you could leapfrog from there on that basis. Just commenting again as a practitioner on the point of judicial scrutiny of any arbitration award, it's something that will, again, speaking for myself, not necessarily for Brit, that we've always found useful. We've never really sort of seen tribunals go off on frolics of their own, even if you look at the different decisions about Twin Towers, whether it's one event or two, how those arbitrations were fought. It's always been helpful for the market to have a degree of scrutiny of that and that option for it to go further. So I for one would, I'm very much in favour of it. And what we don't see in our disputes are disputes of fact, massive disputes of fact. So we don't sort of see that as an issue. So the mechanism of the appeal on the point of law is something that we're quite keen on. Well, from a personal point of view as well, I should say.
Great. Well, thank you. Thank you very much for listening, participating so much. I'm going to hand over to David, who's going to talk about something we're doing for the users. Something we're doing for the members. I've done the users. Thank you.
Thank you very much, Paul. I just want to touch on a arbitrator questionnaire that we have produced for the benefit of arbitrators. It's on the website. I commend it to you. It's not a particularly long document. I want to be quite clear what it is not. It is not groundbreaking. It is not particularly interesting. It is not a warranty that what is disclosed therein is what should be done. It's just a helpful checklist, because in our experience, what is being disclosed by various individuals is not consistent. And there is a difference between what appointed arbitrators who are lawyers disclose and what is being disclosed by people from the market. And what this is seeking to do is just provide a helpful aid memoir as to the types of issue that you as appointees should think about and disclose, to try and help generate some consistency in the market and expectation as to what is to be disclosed. That's what I wanted to say about the questionnaire. If people, having looked at it, find that it is helpful, but it needs to be tweaked, or we should consider adding a point, then do please email us. We'll be grateful. So that is all I wish to say on the questionnaire, unless anybody has any questions about it. Yes, please.
The disclosure provision is 3 years, I think, in terms of prior involvements, relationships.
Well, that's in the IBA guidelines, and as much as one might wish to do something else, they tend to be followed.
Yeah.
Yes, it is 3 years.
But do you leave that in the discretion of the arbitrators if there's something material going back, say, 5 years?
Yes. And again, views do differ, but purely anecdotally, once one gets beyond 3 years and a day, one needn't disclose that other case. It might be different if one gets to 3 years and a day, and therefore I don't need to disclose the 23 appointments I had from that particular firm in 1 year. That would be a little bit cute. So that's why there needs to be some flexibility, but it is 3 years. So I commend that to you. Let's see if it works.